In this series of lectures, we would like to discuss about the industrial and labor law vis-a-vis the constitutional provisions regarding the concept of arbitrariness and unreasonableness. So, in particularly, we would like to discuss first the important landmark judgment, that is Workmen of Hindustan Steel Limited versus Hindustan Steel Limited regarding termination of services as per the provisions under Section 3 of the Industrial Employment Standing Orders Act 1946 and the very provisions as provided under the Constitution of India under Article 311 Clause 2 and Article 14 of the Constitution, which clearly emphasize on the constitutional provisions of equality before law and equal protection of law. So this particular landmark judgment regarding termination of services of permanent employees by the employer. Here the very employer was Hindustan Steel Limited, and it was a landmark judgment delivered by the Supreme Court bench consisting Justice D. A. Desai and Justice B. Khalid in the year 1984. So the very provisions relating to this landmark judgment was relating to the provisions as underlined under Article 311, Clause 2, which provides grounds for dispensations of inquiry and how it must show that it is not practicable to hold an disciplinary inquiry. So, a bare provision of situations contemplated by the provision to Article 311 Clause 2 and contingencies in which a disciplinary inquiry affording a reasonable opportunity of being had before imposing the enumerated penalty can be dispensed with will clearly show that the power is not given to dismiss, remove, or reduce in rank the delinquent worker, but the power confirmed by the aforementioned provision is to dispense with an inquiry before imposing major penalties. So, as per the provisions under Article 311, Clause 3 of the Constitution of India, which provides that if in respect of any such person as aforesaid question arises whether it is reasonable, practicable to hold such inquiry as it was referred under Clause 2 of Article 311 of the Constitution, this decision thereon of authority empowered to dismiss or remove such person or to reduce him in rank, whether it would be final. Now these three situations contemplated by the provisions are such that holding of an inquiry would be counterproductive, where the penalty of dismissal, removal, or reduction in rank is to be imposed on the ground of a conduct which has led to his conviction on a criminal charge. Obviously, the inquiry will be superfluous or a repeat performance because of a judicial tribunal has. So, in this particular landmark judgment, The legal reasoning behind this was relating to Article 14 of the Constitution of India, which relates to equality before law and equal protection of law, and further Article 311 Clause 2 and Clause 3. Besides that, the statutory enactment that was the legal issue was regarding industrial employment standing under Act 1946 and in particularly Section 3 of the Act. So, in this regards, as it was pronounced by Honorable, he then let Justice Desai, as in his own words, Justice Desai expressed in exercise of the power conferred by Section 10 of the Industrial Disputes Act 1947, the government of the state of West Bengal, as an appropriate government, referred the following dispute to the 9th Industrial Tribunal, West Bengal, for adjudication. The reference as read under whether the termination of services of C. Manas Kumar Mukherjee is justified, to what relief, if any, is he is entitled. So the second question raised by Justice Desai, that Hindustan still the employer dismissed Manas Kumar Mukherjee without holding any inquiry and without giving any opportunity to the workman to question or correct the allegation of misconduct leveled against him and in violation of principles of natural justice. So the employer tried to sustain its action by invoking its powers as under the standing orders 32 of the certified standing orders of the Hindustan Steel Limited. Standing Order 32 as it was read under, in particular the special procedure in certain cases. So where a workman has been convicted for a criminal offense in a court of law, or where the general manager is satisfied for reasons to be recorded in writing that it is expedient or against the workman, the interest of security, to continue to such workmen to be employed, the workman may be removed or dismissed from service without following the procedure as it was laid out in the Standing Order 31. So, the very question arises, what exactly the Standing Order 31 prescribed, as it prescribed detailed procedure for dealing with the cases of misconduct. Briefly stated, the procedure as prescribed under Standing Order 31 for imposing major penalties is that the employer has to draw up a charge sheet and give an opportunity to the delinquent workman to make his representation within 7 days. If the allegations are controverted, an inquiry has to be held by an officer to be nominated by the management, and in such an inquiry, reasonable opportunity of explaining and defending the alleged misconduct must be given to the employee. So, in this regard, as we found, so in this particular landmark judgment, as it was held that the employer Hindustan still limited by terminating the very service of Manas Kumar Mukherjee, by violating the very constitutional provisions as underlined under Article 311, Clause 2 and Clause 3 regarding inquiry before taking any such action relating to dismissal, suspension, or removal, which exactly means termination of services as it is provided under Section 3 of the Industrial Employment Standing Orders Act 1946. So, it was a violation of Article 14 of the Constitution of India, which prescribed equality before law and equal protection of law. So, the very decision taken by the employer, and that was Hindustan Steel Limited, was a contravention of the constitutional provisions as underlined under Articles 311, Clause 2, Clause 3, and Article 14 of the Constitution of India, as it completely violates the principle of natural justice. So, the decision regarding termination of services of the workmen concerned in this very important landmark judgment, Manas Kumar Mukherjee, was falling under the clause of arbitrariness and violation of the principle of natural justice.